what are the main topics that I would like to talk about today? Well, the presentation is structured along three main pillars. The first one, to talk about the substantive law rights. It's very difficult to talk about the protection of marriage rights and non-marital registered relationships if we haven't first of all identified what exactly are those substantive law rights which are currently in force in various different states around geographical Europe. Once I've given a brief overview of those substantive law rights, then we'll move predominantly into the case law of the European Court of Human Rights, and then finish off the presentation with a summary of the case law from the Court of Justice of the European Union. Now, with this case law, what I've intended on doing is with the presentation itself, so the PowerPoint presentation, I've provided you with as many cases as possible dealing with the various different topics, and some of those I'll deal with in the presentation itself, and you'll also have the references to those cases which I don't deal with in depth in the presentation, given the short period of time that we have with each other, and to make sure that there's also enough time later for discussion. So let's deal first of all with the topic of the substantive law rights. And when we look across geographical Europe, what we see is a very, very different picture depending upon which country you are located in, or which country to which we are referring to. This map, which is freely available on Wikipedia, and I've checked whether all the various different countries are correct. What we see is that the dark blue countries are those countries in which same-sex marriage rights are permitted. So what we see is that the dark blue area, in all those jurisdictions, marriage is open to parties of the same sex. The light blue areas, those are countries which permit some form of non-marital registered relationship. So think in terms of civil unions, registered partnerships, domestic partnerships, all these different terms that we have across different jurisdictions. We see these being available in various different jurisdictions. Now, obviously, recently, the Greek Parliament has also opted to allow same-sex marriage rights to be open. So Greece will now change from light blue into dark blue. Now, what we then see is that there's also a rather large swathe of red in the far east of the map. And those are countries where there is some form of legislation or constitutional ban on the recognition of same-sex relationships. What we see is then in the middle is that there's this mix of blue and red. And then you can think, well, how is this possible? This is those countries where there may well be a constitutional or legislative ban on the recognition of same-sex marriages, but there is legislation, domestic legislation, dealing with non-marital registered relationships. So, for example, a country may allow for registered partnerships, but have a constitutional ban on the recognition of same-sex marriages. What we also see is that those countries in dark blue, which is not represented on this map, have oftentimes gone through various different stages. The only country to move from no formal recognition of same-sex relationships to same-sex marriage is Portugal. The other countries have gone through some form of recognition, first of all, of registered partnerships. Think, for example, in Germany with the Lebenspartnerschaft. Think in France with the Pacte Civil de Solidarité. Yeah, in Germany in Belgium with the Wettelijke Samenwoning. So we see various different countries going through these phases. Now, with this very diverse and diffuse picture within geographical Europe, it's with this picture that we then need to identify what's actually happening and what has happened with the case law from the European Court of Human Rights and also the Court of Justice of the European Union. And what's important to note as we go into that case law is exactly that trend that I just mentioned. It's not the case that this picture that we now have, this photo opportunity moment of Europe in 2024, is not the situation that the European Court has had to deal with over the period of time. And we see this development that has taken place also being transposed into the case law of the European Court. So let's first look then at the European Court of Human Rights. Now, in order to position the case law of the European Court of Human Rights, it's necessary to take a step back and look at what has the court had to deal with when dealing with same-sex relationships and also homosexual activity. Because then we see that the case law of the European Court can certainly be divided into the various different categories, different trends which have taken place. And it's been a very long road before we get to the case law, which is the most recent case law, which I'll deal with towards the end of this presentation, in which we see the European Court identifying that same-sex relationships need to be provided with some form of formal recognition. Now, that path has been a very, very long road. If we go back to the 1980s, so we're going back now more than 40 years ago, the cases that came to the European Court were not so much about the recognition of the relationships of same-sex couples, but instead about whether homosexual activity should be criminalized or not. And so we see that the debate, which is now taking place, does need to be placed into context. What we see is that this first set of cases were all dealing with whether or not it was possible, for example, in Dudgeon, whether it was possible for the police to enter into houses where sexual activity was taking place of a homosexual nature, and whether that was then against Article 8 of the European Convention on Human Rights. And what we see is that this protection, which was granted within these number of cases, was very much centered on private life. And we'll come on to this development within the context of marriage rights once I've paved this path towards the current recognition. So what we see is that the first set of cases were all dealing with this idea of, can homosexual activity be decriminalized? Very important step, because obviously if homosexual activity is still criminal, it's not even possible to be discussing issues of relationship forms. What we subsequently see is, once then the sexual activity itself is then decriminalized and been put forward into the normal phase of sexual activity, then we see that the debate shifts towards the elimination of discrimination, the idea of equal treatment, the idea of equal age of consent, equal treatment within services, equal treatment within employment. And so we begin to see this development still within the field of private life towards this idea of an elimination of discrimination. That change begins to shift also in the beginning of the 2000s towards this incremental change. Instead of saying that same-sex couples should be entitled to all rights which are entitled to same-sex to different sex partners in a marriage, the debate centers around specific rights which are, in these cases, for example, in tenancy rights. We see tenancy rights which are granted to married couples, which are not granted to same-sex couples. And because same-sex couples are denied entry into marriage, it's therefore also not possible for these couples to gain those access to those tenancy rights. So what we see is that the right itself becomes the issue of debate rather than the homosexual activity. And what happens is that homosexual activity is used as a reason for denying persons these access to these rights. And the European Court begins to analyze this on the basis of Article 14 in conjunction with Article 8. And for each individual right states whether there's a reason this particular right needs to be limited to married couples rather than also being open to people who are not married. Now, this debate happens around about 2003, 2010, and we see then a number of cases coming through, of which these two are possibly the most important, both dealing with the area of tenancy rights. Now, at the same time as this development towards homosexual recognition of homosexuals having rights under the concept of private life, we also see a development happening in the concept of transsexuality. Transsexuality cases mainly dealing with the United Kingdom in the beginning, with one exception of France, with B versus France. But this all had to do with the fact that the birth certificate in the United Kingdom was an historical document. And that historical document registered your sex at the time of birth and was not open to change throughout your life. As a result, transsexuals who changed their sex from their birth sex during their lifetime were not able to change the sex on the birth certificate. And for many, many years, from 1986 up until 2002, the European Court of Human Rights denied transsexuals in the United Kingdom from using then Article 8 to change this legislation. And that changed in 2002 with the case of Goodwin, when the European Court also identified that this not only fell within the right of Article 8, but also was an infringement of the UK government and did not entitle them to the use of their margin of appreciation. Now, these trends, this recognition of homosexual relationships, this recognition of transsexual rights, also led then to a number of different areas of piecemeal debate, right to adoption being discussed in EB in France, parental responsibility rights, child maintenance rights, etc., all dealing with this issue of homosexuality or same-sex relationships. And this brings us then to the context of the marriage debate, the marriage and non-marital relationship debate. And what we first see is exactly what I was talking about at the beginning, stating that the European Court, in first instance, did not want to provide same-sex couples with rights under Article 8, under Article 8, with respect to the right to family life, but only wanted to do this with respect to private life. And so originally the debate was whether same-sex relationships could be covered by Article 8 family life rather than private life. And originally, the X and Y versus the Netherlands, the right to family life for same-sex couples was denied. And only in 2010 was this possible through Schalk and Kopf that same-sex marriage rights were brought with under the concept of family life. Now, this shift in 2010 was a very important shift because that also granted the court more access to the family law right debate under Article 8, which ultimately also led to the extension of these rights to marital and non-marital relationships. Since Schalk and Kopf, what we now see is this standard text being included in these decisions, which was also in Valentinos and Olari decisions, that same-sex relationships are also equally entitled to protection under Article 8, not only with respect to the private life of the individual themselves, but also with respect to the family life of the couple themselves. So this was a fundamental shift in 2010 as we look back in terms of the trends. Now, what we also see is that the negative and positive obligations, that comes back in all of the case law of the European Court. It's not just a negative obligation not to interfere, but we are increasingly seeing in the field of marriage and non-marital registered partnership rights, the positive obligation on a state to introduce registration schemes to allow for same-sex couples to register their relationships. So what we also see is the development of positive obligations also having a positive effect in the protection of these rights across Europe. So what's now happening within the context of these marriage rights? So what we see is this trend across the years from the European Court of Human Rights. We see that having a very strong link to the development of the substantive law discussion, which is also happening. We're seeing an opening up of the development of family life rights for same-sex couples. We also see that the use of positive obligations to stimulate states to change their laws. And we see the debate began incrementally, dealing with various different rights in tenancy, parental responsibility, adoption, etc. What we begin to see is that the European Court of Human Rights originally granted states a very wide margin of appreciation when dealing with issues of same-sex relationships. If we look back at that map, which I started the presentation with, and we see that even in 2024, the map of Europe is very, very diffuse. Even then, if we go back to the 1980s, it was even more diffuse and even less recognition of same-sex relationships. And because that consensus was not available, therefore the European Court granted a wide margin of appreciation to countries across Europe. And we see that that wide margin of appreciation is reduced in certain times. For example, in the Goodwin case, dealing with transsexuality, now that the majority of countries do allow for some form of recognition of transsexuality rights, now the United Kingdom needs to change its laws. What we see is that in recent case law, a recognition that intimate relationships should be granted some form of recognition, regardless of whether it's same-sex relationships or different sex relationships. And we see this coming back in the case law of Schalk, Valentino Solari, Chapin. We see this coming back in all those cases. But that's not really the focus of today's debate. Today's debate focuses more in terms of the marriage and the formalization of relationships. And what we see is that the European Court, at the moment, has not gone so far as to say that states are under an obligation to recognize same-sex marriages. The court has not gone so far as to say that that's necessary. What we see, for example, in the Goodwin case is that the European Court identified that it was necessary for someone to be able to change their sex, change their gender, which ultimately ended up in the gender reassignment legislation in the United Kingdom, that was necessary. But the European Court, especially if we look into the Finnish case, I'm not sure if there's anyone here from Finland, but I'm not even going to try and pronounce the Hämäläinen case. I hope I've pronounced that correctly. But what we see then is there, again, the court saying it's not necessary that countries allow for same-sex marriages. However, what is necessary is there needs to be some form of recognition scheme which allows for same-sex couples to register their relationships. And it's exactly that trend which the European Court has picked up on and set forward in the last set of cases within the last couple of years. What we see in the Feta-Tova case is this idea that countries, which if we go back to our map of Europe, the far eastern side of geographical Europe with the red countries, those countries that do not allow for any form of recognition of same-sex relationships, that is no longer possible according to the European Court of Human Rights. The idea being that same-sex couples should be entitled to some form of formalization of the relationship rights. And I have a quote from the Feta-Tova case against Russia, which basically formed the basis for the same case against the Ukraine, against Romania, and against Poland. We see basically a repetition of the same reasoning coming from these cases, and the same argumentation. But we have a quote from the Feta-Tova case, which I think is crucial in understanding what the European Court is now doing. And what we see is that, I'll read it out, is that the court takes note of the government's assertion that the majority of Russians disapprove of same-sex unions. It's true that popular sentiment may play a role in the court's assessment when it comes to the justification on grounds of social morals. So the first two sentences, what we see is that what the Russian government is saying is we don't provide recognition for these relationships because the majority of our population disapproves of this type of relationship. So even though same-sex relationships are entitled to protection of their family life, and there should be a positive obligation on the state to provide protection, we are claiming a margin of appreciation because the majority of our population does not approve of these types of relationship. So that's the first part of the interesting discussion which is now taking place. And the European Court continues. However, there is a significant difference between giving away to popular support in favor of extending the scope of the Convention guarantees and a situation where that support is relied on in order to deny access of a significant part of the population to fundamental right to respect for private and family life. So what we see here is the use of that argument can be used in order to say, this is why we extend certain rights further, but it can't be used negatively to say this is why we deny certain parts of the population these rights. I find interesting to say that the court uses the phrase to deny access of a significant part of the population. So this is obviously access to same-sex marriage rights and same-sex registered partnership rights, and the court uses the term significant part of the population. I think that's an interesting use of those words. And the court continues, it will be incompatible with the underlying values of the Convention as an instrument of European public order if the existence of Convention rights by a minority group were made conditional on it being accepted by the majority. So these are very strong words on the use of the European Court of Human Rights. So the same idea that we see within the Court of the Court of Human Rights is exactly the same that we've seen within the Court of Justice of the European Union. What we begin to see is the original reticence of any form of recognition. We see, for example, with the D in Sweden case, where the case was about registered partnerships in Sweden and whether they also could be recognized as marriages under EU legislation. And there it was stated, no, Sweden sees these relationships as different, and therefore they're not the same, therefore no protection. And we begin to see, again, this incremental notion dealing with individual pieces of legislation in a very similar fashion to what was happening at the European Court of Human Rights, dealing with tenancy and adoption and parental responsibility rights. And we see the same trend, we see the same tendency happening within the Court of Justice of the European Union. Individual rights being extended because they cannot be justified on the basis of discrimination on the basis of sexual orientation. What we begin to see, and I'll be rounding off the presentation now, what we begin to see is that new legislation comes into force round about the turn of the new millennium, 2004, Treaty of Lisbon, the Charter, the new text of Article 10 of the Treaty of the Founding of the European Union, which grants the court this possibility of really identifying whether it's sex, which is the discriminatory factor, or whether it's actually sexual orientation, which is the discriminatory factor. And this change in legislation grants the court this possibility to also identify whether it's actually sexual orientation. And I think it's probably no news to all of you, the case of Komen, in which then this also was discussed, this idea of marriage rights, the recognition of a marriage from one country within the EU to another country in the EU, and whether then the receiving country is under an obligation to recognize that marriage. And what we see, there was a lot of jubilation in many circles dealing with the decision of the Komen judgment. I think the court did take a certain step forward. However, I don't see it as amazing as many other people, because the court really did limit this recognition of the marriage to that individual piece of legislation. And it wasn't going so far as to say Romania is under an obligation to recognize the marriage in all its context, only just this one piece of legislation in the form of the directive. So what we see is, again, this incremental change. The European Court not going quite so far as to using, for example, the Charter, to using the treaty in order to say countries are under an obligation to recognize each other's same-sex relationships. Where will now the development of the court's case law in the Court of Human Rights and the Court of Justice continue in the future? Possibly the furthering trend towards the recognition in a broader sense, as now has been done by the latest case law of the European Court of Human Rights against Poland, Ukraine, etc. Probably and hopefully that the European Court will also go down that route and say that countries within the European Union have a responsibility to provide some form of recognition to same-sex relationships according to the Charter. So within 24 minutes, I've provided hopefully a brief overview of the case law, the trends, and how we can place this case law in a broader fashion. So thank you very much for your attention, and looking forward to any of your questions that